Lawsuit for personal rights protection. Acting on behalf of European Association Against Discrimination, Contra Discrimination in Warsaw, which represents its members Mr. Paweł Michał Zakrzewski and Mrs. Marzena Zakrzewska, written consent in attachment, on the basis of Article 23 Civil Code and 24 Section 1 in respect of Article 47 of Polish Constitution, I file for order defendant to make a statement with the following content. I apologize for taking effective discriminating actions violating honor and personal rights of Mr. Paweł Michał Zakrzewski and Marzena Zakrzewska in years 2012-2017 by unjustified notice of security authorities and other institutions about the threat of public good from Mr. and Mrs. Zakrzewski, and by initiating this information media campaign. Hanna Gronkiewicz-Waltz, President of Warsaw. The statement shall be published in forms pointed as follows. Press statement published in biweekly magazine Obywatelska, Kornel Morawiecki's newspaper, on page from 2 to 4, one of mentioned pages, at the expense of the defendant with the following characteristics. 1. Published in the red box of width of 3 points on the white background with text separated from box edge with margin not wider than 16 points from every side. 2. Without any remarks, content references on the same page and the next pages. 3. Without using any formal and content procedures understating the rank and the importance of statement, relatively expressing distance for its content and form. Written statement bearing handwritten signature of the defendant, delivered to the plaintiff's registered address. Order the defendant to cover the expense of the lawsuit. Examination of a case even in the absence of the defendant. In the case of defendant's non-appearance, to issue a default judgment. Admission of evidence by court. 1. From the documents mentioned in the grounds for the lawsuit and attached the lawsuit to demonstrate circumstances described there in detail. 1567 pages. 2. From the documents of preparatory proceedings 3DS/622/15 in District Prosecutor's Office, Warszawa, Praga, Północ, as well as files of preparatory proceedings in District Prosecutor's Office in Siemiatycze, closed with valid sentence to discontinue the preparatory proceedings on the grounds of lack of features of a criminal offense in actions undertaken by the executive management body of Salomon schools of Paweł and Marzena Zakrzewski. Proper spending of government subvention with regard to this evidence. Plaintiffs, due to difficult access to files, addresses the local court with motion to obligate District Prosecutor's Office Warszawa, Praga, Północ, as well as District Prosecutor's Office in Siemiatycze to present above-mentioned files. 3. From the documents which are notices from the capital city of Warsaw to other public security authorities, Tax Inspection Office in and outside the city of Warsaw, Union of Polish Metropolises, the Polish Teachers Union, Superintendents of Education, Examination Commission, the Ministry of National Education for the purpose of making use of control protocol and post-control applications in order to discredit and discriminate Paweł and Marzena Zakrzewski concerning the evidence plaintiffs due to difficult access to files, addresses the local court with motion to oblige defendant to present them. Grounds for the lawsuit. Association. Plaintiff acts as an association, which one of the statutory aims are to protect the public interest in the field of discrimination and human rights, with special regard to children and parents' rights, and protection of freedom and human rights. Plaintiff pursues statutory objectives of the association by participating in court proceedings for the protection of public interest as well as important personal interest. Plaintiff ensures special care for its members, on behalf of which initiate court proceedings for the protection of public interest. Plaintiffs' association members are among others Mr. Paweł Zakrzewski and Mrs. Marzena Zakrzewski. Against actions undertaken by the President of Warsaw, Mr. Hanna Gronkiewicz-Waltz, which, in plaintiff's view, are unlawful and violate personal interest of Mr. Paweł Zakrzewski and Mrs. Marzena Zakrzewski. Plaintiff has made a decision to bring these proceedings with aim to alleviate the harm and humiliation suffered by Mr. and Mrs. Zakrzewski. In the state of law, there should not be situations where public servant, by using the office, conducts private interest of third parties in order to eliminate from public life people acting in accordance with law and delivering publicity-demanded educational activity. Filing a lawsuit on behalf of Mr. Paweł and Marzena Zakrzewski finds grounds in the Article 8 of Code of Civil Procedure and Article 61, Paragraph 1.5 of Code of Civil Procedure. For association does not exercise an economic activity and acts for pursuing statutory objectives in the area of protection of every entity exercising educational activity, regardless of whether students are fulfilling their compulsory education in school or out of school. Discrimination of Paweł and Marzena Zakrzewski has taken place through unfounded differentiation of their rights and duties in comparison with other entities exercising educational activity by continual portrays massive controls, ignoring the point of the party, intimidation, putting prejudicial labels, unwarranted notices to prosecuting authorities, social stigmatization, intentional withholding information, Salomon schools, and personalized education. From the social demand coming from parents' belief about the necessity to educate their children in natural environment, which is family, Paweł and Marzena Zakrzewski's initiative was born. The fruit of this initiative was creation of schools and personal education facilities. Introduction to Schools and Facilities activity was collective work edited by Paweł and Marzena Zakrzewski, Home Education in Poland, The Theory and Practice, Warsaw 2009. Within this social initiative foundations, associations, schools and facilities were created to promote and support personalized education in the family. Within this initiative, Psychological Educational Counseling Center of Paweł and Marzena Zakrzewski's in Warsaw was founded in 2011, and Paweł and Marzena Zakrzewski's Salomon Primary School in Warsaw 2011. Paweł and Marzena Zakrzewski's Middle School in Warsaw 2011. Paweł and Marzena Zakrzewski's Salomon's High School in Warsaw 2011. Paweł and Marzena Zakrzewski's Salomon Middle School in Drohyczyn 2015. Paweł and Marzena Zakrzewski's Salomon High School in Drohyczyn 2016, hereinafter referred to as Salomon Schools. Salomon schools exercise educational activity in line with currently enforced law of September 7, 1991 on the educational system and implementing regulations, respected provisions of the law, especially those referring to Section 8, schools and non-public institutions. Salomon schools had status of non-public schools with rights of public schools. According to Article 16, paragraph on the educational system, Salomon schools headmaster, upon request of student parents and positive psychological educational counseling opinion, issued a decision allowing students to fulfill compulsory education out of school. Based on Article 90, paragraph 2a on educational system law, Salomon schools possessing public schools rights have been granted a subvention on students from local authorities on the area where schools had their offices, that is, the capital city of Warsaw. Subvention was granted regardless of how students fulfilled their compulsory education. When students fulfilled compulsory education out of school, Salomon schools conducted annual classification exams, organized classes developing interest and talents, teaching and educational classes, as well as specialized classes for students requiring specific aid in development or other help. That was based on the Article 16, paragraph 11 and paragraph 13 in relation to Article 64, paragraph 1.2, 5, and 6, Act on the Educational System. Salomon schools in Warsaw have been attended by students fulfilling compulsory education stationary as well. Salomon schools were essentially associated with Mr. and Mrs. Zakrzewski, who were developing an out-of-school method of education in Poland, as well as abroad. So an innovative personal education program was born. School textbooks, educational boxes, a pioneering research on the matter of education and family have been carried out. Within home education, a compulsory school education is conducted out of school, where parents, along with the school, arrange the process of child's education. Salomon School's main object was to support parents, that is, parents teaching their children within personalized education, and the ones teaching out of Poland. This goal was pursued through an innovative e-learning platform, arranging family reunions, educational meetings, theme and subject workshops, meetings with the authors, music concerts, sightseeing tours, and exams where children presented their acquired knowledge. For such activities, Salomon School obtained funds through, among others, donations by Mr. and Mrs. Zakrzewski. Paweł and Marzena Zakrzewski arranged a number of conventions and conferences focused on the matter of personal education in family. Significant here was the last conference that was held in Belvedere in February 2016. Among the representatives of science and art, families involved in home education, Ministry of Education representatives were present, Undersecretary of State, and President's Office, Secretary of State. The conference was mainly devoted to threats for further personalized education development caused by actions of capital city of Warsaw. Burdensome inspections aimed at dig up dirt on Salomon schools and Paweł and Marzena Zakrzewski. When Salomon schools gained on popularity, the harassment started with numerous intensive inspections everywhere where the surname Zakrzewski came up. This can indicate that inspections were aimed at persons, not schools. The president of the capital city of Warsaw, Mrs. Hanna Gronkiewicz-Waltz, was the initiator of those procedures. The inspection bodies, acting jointly and in cooperation, exchange every necessary information to achieve the intended objective, which was neutralization of the community affiliated with Paweł and Marzena Zakrzewski. Inspection carried out between 27th of May till 27th of June 2014 by the Inspection Office of Capital City of Warsaw, hereinafter referred to as I.O., was the most severe one. Inspection was related to spending subventions for Salomon schools. Inspection has ended by drawing up a protocol number KW-I.1712.56.2014.BLE, hereinafter referred to as a protocol. The process of carrying out an inspection gives rise to a number of doubts. Note UD-VII-WOW.4431.41.2014 MHE from 27th of January, addressed to Deputy President of Warsaw, Mr. Włodzimierz Paszyński, has initiated inspection at Salomon schools. The reason for inspection was the fact as emphasized that students are fulfilling the compulsory education out of school. Public officers were prejudiced against Salomon schools and homeschooling. In one of correspondence, email from Ministry of Education to the Mazovian Board of Education, before verification, the number of Salomon school students was questioned. According to Supreme Court's verdict WA3/13, this act meets aggravated offense specified in Article 231, Paragraph 2 of Penal Code 4. It is characterized by psychological attitude toward the inspected party. The inspection was carried out based on implementing law from 7th of September 1991 on the educational system, specifically the regulation of Ministry of Education from 7th of September 2009 on pedagogic supervision, Journal of Laws of the Republic of Poland number 168, position 1324, and from 2013, position 560, which, in paragraph 12, section 3, states that inspection carried out in school or establishment cannot interrupt the work of school or establishment. Inspection should not exceed more than 2 working days. Initial authorizations number 74/2014 and 75/2014 from 26th of May 2014 were valid until 17th of June 2014. They were extended twice, at first until 25th of June 2014, then until 27th of June 2014. Repeated prolonging inspections by I.O. and Salomon schools demonstrate a negative attitude of Warsaw authorities, which lies in seeking for any irregularity in Salomon schools until the desired effect. Inspection took a month instead of 2 days. Moreover, it was carried out during the middle of classification exams, external exams, science championships, and the end of the school year. I.O. inspection authorization number 74/2014 and 75/2014 from 26th of May 2014 were issued in contradiction with the applicable authorization template being annexed to Warsaw President's Ordinance number 4155/2010 from 1st February 2010 on the procedure and rules of inspection, which contradicts paragraph 8, section 4 of invoked ordinance. During IO inspection, the Salomon School's management and representative of investigating authority gave detailed explanations requested by inspectors and IO management, and also after the inspection. Explanations were signed by inspectors and other IO employees. One note from 6th of July 2014 includes 1,747 pages of certified true copies of school's documentation confirmed by a lawyer representing Salomon Schools. It should be pointed that IO representatives falsely and deceitfully accused Salomon Schools for not providing explanations. According to Article 231, Paragraph 1 Criminal Law, public officer commits a crime who exceeds his authority in acting against not only public interest, but also private. The inspection report was prepared unreliably. It required numerous corrections and clarifications, dubious entries, and eventually, after 4 months after the end of the control was left, signed with many reservations by representatives of the controlled Salomon Schools. From that time, the president of the city of Warsaw began to inspire disinformation activities and defamatory school Salomon, and in this way prepared the desired social effect for post-control occurrence. Both the duration of the inspection and preparation of the protocol, post-protocol after a delay of 4 months from the control, and finally drawing up the speech after almost 1 year. Post-control check evidenced the delay proceedings within the meaning of Article 35 of Administrative Code. It should be added that post-audit statement was signed on March 26, 2015 personally by the mayor of the city of Warsaw, but due to intentional incorrect delivery and thus the publication of the document effectively delivered on May 11, 2015, as confirmed in the letter from the capital city of Warsaw. Please attach an attachment that according to the content of Article 212 Penal Code, responds for defaming the one who is talking to another person, a group of persons, institution, legal person, or an organizational unit without legal personality for such conduct or inappropriateness that may affect public opinion or jeopardize confidence needed for a given position, occupation, or type of business. Undoubtedly, such statements that set aside in form of a fatal accusation may also appear in testimonies before the parish body of Appellate Court in Warsaw of June 24, 2016 to AK 73116 reads that the subject of the offense of abusive incidents in the basic type consists in the operation of to detriment of public or private interest by overrunning entitlements or failure of the official by the public official. Harmful action means that behavior of the perpetrator creates a state of danger for the legal good in the sphere of public or private. Post-audit statement, Mrs. Hannah was entirely appealed by the proxy representing Mr. Paweł Michał Zakrzewski. In a letter dated 21 May 2015, the reply to post-audit statement primarily criticized the lack of knowledge by inspectors, the basic and specificity functioning of the so-called home teaching and the mode of its implementation, and such a personal threat policy of this speech, as well as directly conducting the same control, evidence, correspondence with Andrzej Duda Campaign Committee, Correspondence with Paweł Kuki's campaign committee attached. The significance of this sentence proves that it was met with the necessity of calling a special meeting with the participation of Deputy President of City of Warsaw, Mr. Włodzimierz Paszyński. Evidence letter from capital city of Warsaw BE-WF 10.4431.2.39.2015.AFI, dated 3rd June 2015 attached. By letter KW-W.I.1712.56.2014.BLE of 30 July 2015. Deputy President of Capital City of Warsaw, Mr. Włodzimierz Paszyński, informed the authorities district with no reservations or comments. He also ordered the initiation of procedures for issuing administrative decision regarding the return of the part of subsidy. The response of the Salomon School attorney from the law office of 31st August 2015 were also not taken into account. Activities regarding the Salomon schools were forwarded to the message of the mayor of the capital city of Warsaw, Hanna Gronkiewicz-Waltz. Proof: letter KW-W.1.1712.56.2014.BLE of 10th June 2015 attached. Activities of the mayor of the city of Warsaw, Hanna Gronkiewicz-Waltz, and subordinate persons and offices entered into conflict with Article 231 of Penal Code by exposing the interest of the private sphere, the good name and honor of Zakrzewski family, and the public sphere, the good of community related to education in the schools. In carrying out her own interest, the president of City of Warsaw, Hanna Gronkiewicz-Waltz, compromised the authority and office. The subject of the protection under Article 231 of Penal Code. There is any legal interest, regardless of whether it belongs to the private sphere or the public sphere. This provision directly protects the proper functioning of the state institution and local self-government and the related authority of public authority. In the type of this offense, the act of execution is detriment of the public or private interest in a strictly defined way, namely overrunning or failure to fulfill obligations. Supreme Court judgment of 27th of October 2014, WA 23114, Lex number 155434-0. The executive action provided for in the Article 231 of the Penal Code consists in acting to detriment of a public or private interest, which is to take place when the official's behavior may result in damage to public or private interest. The concept of damage should be understood here broadly. It is not only about property damage, but about every exposure to a good protected by law. President of the City of Warsaw, Hanna Gronkiewicz-Waltz, through her own actions and subordinate offices, exposes the rights of Paweł and Marzena Zakrzewski spouses, in particular the honor and authority in the eyes of society, including students and parents of Salomon schools. It should be noted that already on March 25, 2015, before any final decision was issued, Mr. Włodzimierz Paszyński, Vice President of the Warsaw City, addressed the letter BEWF 10.440.6.2015.AFI to the Minister of National Education with the proposal considering change provisions to the disadvantage of students included in out-of-school education. And on 26 March 2015, President of City of Warsaw, Hanna Gronkiewicz-Waltz, sent a letter to the district of Praga Północ with a recommendation to issue a decision on the return of the subsidy. On April 2nd, 2015, letter BE-WF10.4431.2.29.2015.LPA, the city authorities applied for an inspection at the Salomon schools for 2014. It is justified to quote here the provisions of the Supreme Court of 7th March 2014, V-KK318113, from which we can learn that a state officer within the meaning of Article 115, paragraph 13.4 of the Labor Code, unlike persons from other categories mentioned in this provision, is realized when it performs duties to the extent that it is authorized to issue administrative decisions, a condition for her to bear responsibility under Article 231 of the Penal Code, defining the types of individual offense. It is therefore that overriding or failure to fulfill obligations to the detriment of the public or private interest occurs to the extent to which it is entitled to issue administrative decisions. Actions cited by Mayor of City of Warsaw, Hanna Gronkiewicz-Waltz, testifies to putting pressure on subordinate institutions to harass the social environment grown by Salomon schools of Paweł and Marzena Zakrzewski. In the commentary on Article 231 Penal Code, we read that the object of state protection is proper functioning of state institutions and local self-government, and the resulting authority. In addition, in September 2015, the city authorities, through the deputy mayor of the city of Warsaw, Mr. Włodzimierz Paszyński, sent another request for control at Salomon schools. It should be noted that in writing KW-W.1.0632.7.2015.BLE of September 29, 2015, to the Deputy City of Warsaw, Mr. Włodzimierz Paszyński, the director of BKU refuses to initiate control. In addition, it informs that the previous Salomon School Board has the right to submit explanations regarding the inspection. This is confirmed by the fact that the authorities of the department subordinate to the city mayor themselves often admit that they refuse the Salomon schools of Paweł and Marzena Zakrzewski due to them by virtue of the laws. Letter BE-WF10.440.9.2015.AFI, dated 17 June 2015, Deputy President of the City of Warsaw, Mr. Włodzimierz Paszyński, exerted pressure using the Union of the Polish Metropolises for a legislative change in the field of out-of-school education. Clearly, the goal of this initiative was to discredit Paweł and Marzena Zakrzewski in the reception of the authorities of the Metropolitan Union, as well as the Ministry of National Education, despite the lack of an administrative decision immediately after the signing of the protocol, but before the post-control comment from 14 November 2014, the opinion of legal advisors regarding the functioning of the Salomon schools were adjusted, which ultimately led to submitting in 2015 an unjustified notification to the Central Anti-Corruption Bureau by the mayor of capital city of Warsaw. It also became the basis for analogous actions taken by ad hoc board and ended with submission of another groundless notification to the Central Anti-Corruption Bureau and the District Prosecutor's Office in Warsaw. It should be noted that the CBA did not initiate proceedings against Paweł and Marzena Zakrzewski in this respect, while the prosecution proceedings were validly discontinued. In the commentary on Article 224A of the Penal Code, read, "The subject of protection seems to be the correctness of the operation of public institutions, security bodies, public order, or health. Acting casually consists of notifying an event that threatens the life or health of many people or large-sized property, which notice results in action of a public benefit institution or body protecting security, public order, or health aimed at to set aside a threat or to cause a situation which is the authority of an institution or the authorities to convince of such a situation threat. The notification may be made in any form. It is important that the perpetrator notifies about the occurrence of an event that threatens the life or health of many people or property in large sizes. The second mode of action of the perpetrator, specified in the commented regulation, is to create a situation, that is to convince the existence of a threat. This is all the case of behavior that can result in a conviction about the existence of a threat. The crime is effective. By the act indicated in the content aimed at repealing the non-existent threat, it is not a sign of an offense calling any state of danger. It is enough to call an action to repeal it. It does not seem necessary to convince the body or institution of the existence of a threat, due to the fact that, in principle, any notification about the existence of a threat or any situation that could potentially evoke even a very low likelihood of occurrence in practice often means that actions must be taken to repeal the threat, invoking the existence of a situation. Due to the effective nature of the crime, it is made only when the body or institution takes steps to repeal the threat. When the authority or institution does not take any action, an attempt is made. The prohibited act in question is a universal vice. It may be allowed by any person who is liable to criminal liability. The act is intentional. It does not yield doubt that it can be committed in a direct intention. It is an action to evoke conviction. One can justify that it is impossible to commit an offense in any event, and the act itself has the character of predicate offense. Because if the behavior of the perpetrator is to evoke certain conviction on the part of an organ or institution, it can be in this case. A direct purpose is forbidden to exist only in terms of conviction, for this is referred to in the content of the rule of the participle having. Therefore, if the action is called, it does not have to be covered by direct intention anymore. The coincidence of the commented provision in Article 66, this provision penalizes a public utility or body protecting security, public order or health, and therefore the same entitles referred to in the commented provision. In the event of an offense under Article 66, the perpetrator works wanting to trigger an unnecessary act, while in the case of the act, he acts wanting to convince the existence of a threat, while possible further effects in the form of taking action by the organ or institution, the perpetrator does not have to it is enough to agree. In addition, the command provision covers only the notification of a threat, while Article 66, information or other method aimed at triggering an unnecessary action. This means that, in a concrete factual situation, the marks specified in both of the analyzed provisions may cross. What is worth emphasizing, it is possible to simultaneously exhaust the statutory marks specified in the commented provision in Article 233, false testimony, and 234, false accusation. Article 236, cunning referral against another person. And finally, Article 238, notification of unpunished crime. It seems that in all cases the cumulative qualification will be appropriate. The controls did not only refer to issues related to the running of the Salomon School, but also personally related to Mr. Paweł Michał Zakrzewski and Marzena Zakrzewska. President of the capital city of Warsaw sent to the Tax Control Office numerous notifications referring to financial issues Zakrzewski family. The basis for notification to tax offices is also the control protocol and post-inspection statement. It should be noted that the actions taken by the president of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, and its subordinates against Paweł and Marzena Zakrzewski violate the provisions of Article 234 of the Penal Code. Type of crime specified in Article 234 Penal Code. It is not only characterized by intentional action or even direct intent, and it is enough for the survivor to agree to false accusation of another person for committing a crime. It should be noted that the activities of the mayor of capital city of Warsaw, Hanna Gronkiewicz-Waltz, resulted in the loss of trust among the parents of Salomon School students. As a result of using the post-control statement, an investigation was initiated and conducted by District Prosecutor's Office, Warszawa Praga Północ in Warsaw, under 3D/622/15. Reference to the Act of Article 297, Paragraph 1 of the Civil Code, in conjunction from Article 12 Penal Code. It should be noted that the district authorities immediately informed the Deputy President of the capital city of Warsaw, Mr. Włodzimierz Paszyński. The proceedings in question were discontinued. The prosecutor did not find any committing a crime by the organizing authority of Salomon, and consequently did not bring an indictment. It should be emphasized that false accusation, as referred to in Article 234 Penal Code, is made when the content of the accusation containing untrue allegations reaches the author, which is the body appointed to prosecute or adjudicate in cases of crime, including fiscal offense, fiscal offense, or disciplinary offense. The motives of the perpetrator are indifferent to the existence of the crime in question. In turn, the misdemeanor of Article 238 Penal Code, notice of unpunished crime, differs from the offense under Article 234 of the Code of Civil Procedure that the perpetrator, by notifying an authority appointed to prosecute offenses or taxed offenses with an allegedly committed crime, does not indicate the person who was to commit them. The above unsubstantiated reports to the prosecutor's office caused that the law enforcement agencies question parents of Salomon School students, which directly affected the negative perception of Paweł and Marzena Zakrzewski. It should be emphasized, after the verdict of District Court in Kielce of 6th December 2013, this offense is an offense, but the result is exposure to the public humiliation or loss of confidence needed to occupy the position, not whether this affect in the form of humiliation or loss of position or other negative consequences connected with it actually occurred. And also for the verdict of District Court in Zamość of June 24, 2013. Damage referred to in Article 231, Paragraph 1 Penal Code does not have to be of a material nature and may also be a moral nature. Postal control posting by authorities of the capital city of Warsaw to various institutions has released a number of repressive measures in relation to Salomon schools Paweł and Marzena Zakrzewski. At this point, we document one of the most oppressive controls carried out by City of Warsaw on the basis of denied resolution number 560/2015 of the Praga Północ District Board of the capital city of Warsaw, dated 14th April 2015. The very next day after the City of Warsaw adopted resolutions, without any information about the control, a group of 12 supervisors entered the Salomon school during classes and the schools during the examination, completely disrupted the work of Salomon school's pedagogical staff, and the control group tried to force the unauthorized persons to represent the Salomon schools or the leading authority. In a common perception of the school community, the activities of the control group inspired by the city authorities were perceived as harassment and overt discrimination aimed at disorganization and liquidation of the attacked institutions, as well as, in consequence, affecting the good name of Paweł and Marzena Zakrzewski. Incidentally, the Supreme Court's judgment of 5th October 2016, which reads, inducting a specific person to give false data, presenting facts that are inconsistent with facts, including in the context of statement made by him, is worth mentioning here, and deposition, as well as creating false evidence in this way to direct against another person. Prosecution of a crime, including fiscal offense, fiscal offense, or disciplinary offense, fills the sign of a prohibited act specified in Article 235 of the Penal Code. It should be emphasized that the control referred to above is the result of a campaign conducted by the President of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, on the Zakrzewski's family by unreasonably sending a defective post-control statement to state and local government institutions. For the action of a public official to the detriment of public or private interest, it is not necessary for any damage to the protected property to occur, and it suffices that there is a threat to that prejudice. Activities of the President have inspired and authorized the facade of defamation, slander, and operational activities aimed at the Salomon schools. It is worth mentioning here that decision of the Supreme Court of 22nd June 2004, WKK 70/0, defamation made with the awareness of the falseness of information and assessment about the proceedings and the properties of another person, Article 212, Paragraph 1 and 2 of the Criminal Code, never serves the purpose of socially justified defense interest, Article 213, Paragraph 2 of the Penal Code, and such behavior does not benefit from the protection granted to freedom of expression and the right to criticize by Article 31, Paragraph 3 of the Constitution of the Republic of Poland, or Article 10, Paragraph 2 of the European Convention on the Protection of Human and Basic Freedoms. An important evidence in this matter are the letters of the Parent Council of April 21st, 2015, to the Mayor of Praga Puno's district for the cessation of harassment towards the primary school, junior high school, and high schools, Salomon of Paweł and Marzena Zakrzewski. It can be seen in a very short time how the president of capital city of Warsaw, Hanna Gronkiewicz-Waltz, has translated into public pauperization of Salomon schools, and consequently directly hit the good name of Paweł and Marzena Zakrzewski. It should be mentioned here the judgment of the District Court in Kielce of December 11, 2013, in which we read, offense of a libel on Article 212, Paragraph 1, Penal Code is an intentional crime, and the perpetrator with his behavior seeks to sue another person for such conduct or property that may humiliate it in public or expose him to loss or confidence needed for a given position, profession, or type of activity. It should be emphasized that the submission of information on the actual number of students in the Salomon schools was always in accordance with the deadlines and procedures set by the office. In addition to the ODPN system, Subsidy Service System for Non-Public Institutions, the school authorities submitted information through the law office and the accounting office. Therefore, there was no justified premise for such massive control. In addition, the school gives access to necessary documents and every request of the capital city of Warsaw, which is well illustrated by the part of the correspondence with the Education Office of the capital city of Warsaw. It should be noted that offices servicing schools were in daily contact with the city of Warsaw and provided necessary documents upon request, which involved generating significant additional costs on the part of the owner of the establishments. The only reason for the control in such an addition could only be the desire to execute an order for Salomon. This fact should be closely linked with the actions of the president of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, who sent her post-control speech, which was only her subjective feeling of so-called irregularities in the spending of money by Salomon schools, Paweł and Marzena Zakrzewski, presented the Zakrzewski family in a falsely bad light and forced subordinate persons to take actions against the Salomon establishments, including filing unsupported notices and initiating the merged controls. Penal Code. False accusation is a common crime. If the perpetrator is a public official who exceeds his powers, then there is a cumulative qualification, Article 231, Paragraph 1 or 2 in conjunction with Article 234 in conjunction with Article 11, Paragraph 2 Penal Code. And further, it is an intentional crime that can be committed with both direct and possible intent. The type of offense specified in Article 234 of the Penal Code is not characterized by intentional action, nor even intent direct, and for his being, it is enough to agree on the offender to falsely accuse another person of committing a crime. We will start this point by quoting the quotations from the commentary on Article 235 of the Penal Code. The object of protection is the proper functioning of the justice system and the good name of the person against whom the prosecution is directed. The effective act consists in directing against another person prosecution for crime, fiscal offense, disciplinary offense, by creating false evidence or other sneaky actions, or if proceedings are already initiated, creating false evidence in the course of the offender, or undertaking other treacherous actions. made with the use of deceit, and the perpetrator may even act by a third party. False evidence is false, and inaccuracy must manifest itself both in objective and subjective aspects. If the evidence was true, although the perpetrator was convinced about its falsity, it may be an inept attempt. An offense under Article 235 takes place regardless of whether the person against whom the false evidence was created is guilty or not to perform an act. If the creation of false evidence took the form of counterfeiting or reworking of the document, the cumulative classification of Article 235 of Article 270, Paragraph 1, and if the perpetrator uses false documents, we can deal with the cumulative qualification under Article 235. One such tricky procedure used by city authorities of Warsaw seems to be the establishment of an emergency committee on 9th April 2015, the purpose of which was to authenticate the BKU control and violent actions undertaken under the pretext of alleged irregularities in Salomon schools. In effect, of ad hoc committee's activities was, among other things, to convince, despite the unsettled administrative procedure for reimbursement of subsidies, that the Salomon schools illegally expended funds. Through the activities of the ad hoc board, the district council passed a resolution on making changes to the rules for granting subsidies for non-public schools, and the activities led by the president of the city of Warsaw, Hanna Gronkiewicz-Waltz, contributed to the negative perception of Salomon schools and out-of-school education, as evidenced by the statement of one of the Warsaw's councillors. Further discussion on this subject makes no sense and should be prevented as soon as possible. A further precedent, which is the functioning of the private school Salomon. From the letter of 14th July 2015, the office of the organization of the capital city of Warsaw clearly shows that the changes proposed by the council are contrary to the provisions of the Act on the Education System. In the meeting of the Commission on 24th November 2015, the president of the teacher union of the Polish branch Praga Północ said, "The example of the Salomon school showed the existence of possibility of legal extortion in the existing system, the legal status. This consists in the whole when we combine this statement with the statement of the head of the education department of the Praga Północ district office, who in a conversation of April 24th, 2013 with the legal representative of the Salomon schools, he warned that Salomon schools are under the observation of people from the Polish Teachers Union having its headquarters nearby. Today, knowing these facts and the address of the Salomon schools, Namysłowska 4 Street, and the Praga Północ PN8 Namysłowska 1 Street, we can state that actions directed against the Salomon schools were planned and implemented on many levels, from the mayor of capital city of Warsaw, Hanna Gronkiewicz-Waltz, and ending with the obliging chairman of the Polish Teachers Union. What is worth emphasizing, the Salomon schools collected only part of the subsidies due. This was to a large extent dictated by caution resulting from the growing lack of tolerance and even hostility on the part of the city authorities. For example, in the letters from January 15th, January 16th, January 22nd, and January 31st, 2014, delivered personally to the capital city of Warsaw by an authorized attorney, school attorney, and director of the school, the fact that Salomon schools did not receive funds for students enrolled in underlined from September 2013, which is documented by the report of the Educational Information System. Proof. letter sign UD-VIL-00.4431.37.2.2014.MHE, or the capital city of Warsaw attached. Unlawful suspension of subsidies due to Salomon schools. The discrediting actions of the mayor of city of Warsaw, Hanna Gronkiewicz-Waltz, resulted in the unlawful suspension of subsidies for Salomon schools. These actions led to a significant deterioration of the financial situation of schools. The Zakrzewski family was forced to look for other sources of financing Salomon schools in Warsaw, not for the first time, mainly at the expense of their private property. In 2012-2015, this and other similar activities followed the forced depletion of the private property owned by the Zakrzewski family to over 7 million złotych. It should be noted that these sales made under the pressure of time and current financial obligations were unfavorable for the sellers. The appraisers valued the sold assets for an amount of over 11 million złotych. The plaintiff seized the direct translation of actions discrediting the persons of the Zakrzewski family, forcing them under the pressure of maintaining a good name in the environment of pupils and parents of Salomon schools, to dispose property unfavorably by forced sale of the property they owned. It is worth noting here the content of the decision of Supreme Court of October 14, 2010, stylization of Article 212, Paragraph 1 Penal Code leads to the conclusion that the grounds for criminal liability under this provision can only be said if the perpetrator has communicated to at least one person, or in the presence of at least one person, information about the proceedings or properties of another person who may humiliate it in the public opinion, or in the presence of at least one person, information about the proceedings or properties of another person that may humiliate him or her in the public opinion, on the loss of trust needed for a given position, occupation, or type of activity. Seizure is a formal offense of exposure for which no effect in the form of real humiliation or loss of trust by the victim is required. Speech only then is subject to criminal liability when it involves the possibility of moral harm to the injured party in the form of the possibility of humiliation or exposure to loss of confidence. The provision of Article 212, Paragraph 1 Penal Code speaks not of humiliation at all, but humiliation in public opinion, which means that it is not so much about the grudge of the victim's personal feelings, but about how the offended person will be perceived by a wide, unspecified circle of people. Such libel, which may lead to humiliation of a given person in the opinion of other people, cause that other people consider the victim to be a humiliated person. Based on the natural family environment, it is worth pointing out the court's view. Grant is granted in Article 231, Paragraph 1 Penal Code. It is not formal, but is of the material nature, a crime of a particular exposure to danger, being a significant result which is the occurrence of a risk of damage in the public or private interest. Order of the Supreme Court of 16th April 2014. The activities of the authorities of the capital city of Warsaw which led to the suspension of subsidies for the Salomon schools in 2015, were taken despite the fact that the subordinate Mrs. President of the capital city of Warsaw, Hanna Gronkiewicz-Waltz institution and knowledge offices significant legal uncertainties in the discussed area. By letter UD-VII-4431.164.2015.BBA dated 21st April 2015, addressed to the President of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, through Mr. Włodzimierz Paszyński, Deputy President of capital city of Warsaw. They were informed that the transfer of educational subsidies for Salomon schools will be unlawful. At the same time, the same district office in the letter UD-VII-WOW.4431.165.2015.BBA on the same day, April 21st, 2015, informs the Educational Office that there are no grounds for no part of education subsidy for the month of April 2015 transferred by the district in accordance with the provisions of the above-mentioned resolution. In a letter addressed to the mayor of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, through the intermediary of Mr. Włodzimierz Paszyński, the deputy president of the capital city of Warsaw, seems contradictory. However, in the letter UD-VII-WOW.4431.164.2015.BBA on 21st April 2015, we clearly notice that the district authorities make their decision conditional upon the granting of binding instructions by the deputy president of the city. The list of these documents unambiguously indicates the final decision maker in matters related to the Salomon schools. President of the capital city of Warsaw, Hanna Gronkiewicz-Waltz. The structures of the Warsaw City Hall themselves have come to the conclusion that, in the light of the binding legal status, it is not possible to withhold the subsidy of a non-public school in which the school obligation or the obligation to learn is fulfilled. Proof: legal opinion of 5th May 2015 attached. It is worth emphasizing here the decision of the Supreme Court of 27 September 2013, assigning an act from the Article 231, Paragraph 1 of the Penal Code requires proof of a real public or private interest as a result of improper operation of public official. Also, in the letter of the office from 14 July 2015, the city confirmed once again that, in the light of the current legal situation, it is not possible to stop the subsidy of a non-public school in which the school obligation or the obligation to learn. The president of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, only after more than 14 months after completing the control in the Salomon schools, personally initiated the administrative proceedings by letter from 8 September 2015 regarding the return of the grant. It should be noted that in this period, instead of dealing with a thorough explanation of this matter, the president of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, deliberately led to a loss of financial liquidity and loss of good name, and consequently the collapse of Salomon schools. The actions described earlier were aimed at depriving the honor and the reputation of the Salomon schools of Paweł and Marzena Zakrzewski and not the willingness to explain the matter. The evident pre-planned action was the recommendation to include in the 2016 budget the funds returned by Salomon schools, despite the lack of administrative decision issued 2 years after the end of the audit. On this subject, plenipotentiaries of the schools always reported the comments and reservations on the ongoing administrative proceedings as evidenced by letters addressed to Mayor of City of Warsaw, Hanna Gronkiewicz-Waltz. However, the party's explanations have never been included in the decisions of the city. In general opinion, giving a 7-day deadline to become acquainted with the massive material collected by the city in the period from May 2014 to November 2015, over 1.5 years, in the proceedings is harassing and receiving by the municipal office the right to defend its ration and good name. The insurance of an administrative decision regarding the return of the part of the educational subsidy also seems to be pushed up by the knee. Just like in the post-control statement, the opinions of the lawyers of the city of Warsaw are divided. According to BE-WFIO.44.31.2.2015.AAFI, dated 8th March 2016, the Education Bureau reports 6 significant legal errors, and the legal opinion of 8th April 2016 points out numerous formal errors in the decision, citing the justification for the judgment of the Supreme Administrative Court and the Administrative Court. The decision of the Mayor of City of Warsaw from 26th July 2016, number 1/20I6, regarding the determination of the amount due for a subsidy used contrary to the intended use to the return to the budget of the capital city of Warsaw, was challenged by attorneys at Law Office Czarni Porębscy I Wspólnicy. Marzena Zakrzewska, legal advisor of Maciej Mekliński to the local government appeal court in Warsaw. However, it does not follow from the knowledge that the appeal has been handed down to the present day, 12 months, by the mayor of capital city of Warsaw, Hanna Gronkiewicz-Waltz, to the SKO in Warsaw. An administrative decision was issued within 3 days of the inspection. The administrative procedure concerning the return of the subsidy itself lasted over a year in a situation when Article 35, Paragraph 3 of Administrative Code provides that even a particularly complex case should be dealt with no later than within 2 months from the date of initiation of the proceedings. Therefore, the decision issued by the first instant body by Mrs. Hanna Gronkiewicz-Waltz took place as a result of prolonged inactivity, and the lengthy conduct of the entire proceedings took place with a flagrant violation of the law, in accordance with the judgment of the Supreme Administrative Court in Warsaw from 28 March 2017, reference number 2OSK 133/16. Currently, the concept of inaction should be limited, above all, to failure to issue an administrative decision within the deadline. By the concept of chronic driving, on the other hand, conduct should be understood as the situation of conducting proceedings in a manner ineffective by performing activities in a large period of time, or performing sham activities that cause the organ is not idle. Similar in this, the position was taken by the Supreme Administrative Court from April 21st, 2017, reference to OSK 532/16, stating that which the protracted proceedings we have, when the proceedings is lasted longer than necessary to resolve the case. and also the Supreme Administrative Court in an except of 21st April 2017, reference number 2 OSK 521/16, referring to the activities undertaken by the body apparently irrelevant to the substantive settlement of the case. Until now, the appeal was not transferred by the President of the capital city of Warsaw to the authority of the second instance of SKO, which is an extremely persistent and blatant violation of the law. Article 133 of Administrative Code constituting the public administration body that issued the decisions is obliged to send an appeal along with the files of the case to the appeal body within 7 days from the day on which it was received. Cancellation, if within this period it has not issued a new decision pursuant to Article 132. In this regard, Thesis verdict of Supreme Administrative Court of 10th January 2012, reference number 2 OSK 1999/10 reads: the period specified in Article 133 of Administrative Code, it is a time limit. The only act that the first instant authority can take after expiry of this date, there is material and technical activity to forward the appeal together with the files, matters to the appeal body. Similarly, in the Supreme Administrative Court's resolution from 19th June 2012, reference number 2 GSK 869/11, it was stated that the public administration body which issued the decision is obliged to send the appeal together with the file to the appeal body. That is the authority which, on the basis of the relevant competence standard, is the competent authority to recognize appeal. The decision of the Mayor of Capital City of Warsaw from 24th May 2017, number 1/2017, on the determination of the amount due for a subsidy not used for the purpose intended to be returned to the budget of the Capital City of Warsaw is one of a similar nature. She also appealed to the local government appeal court in Warsaw. From the information obtained at SKO, appeals were not forwarded by President of the Capital City of Warsaw, Hanna Gronkiewicz-Waltz, to the superior institution. In a reply dated 23rd July 2015, the Deputy President of Capital City of Warsaw, evidence letter from 23rd July 2015 attached, writes down for serious objections of the party to the post-control statement, unprecedentedly denying the existence of evidence collected during control. During control by BKU inspectors and the lawyer representing Salomon School on June 6, 2014, the fact of receipt of these documents is confirmed in writing by the controlling BKU document confirmation of receipt of documents dated 6 June 2014 enclosed. In addition, the documents did not appear in the course of the administrative proceedings. Evidence letter UD-VII-WOW 449.2015.WSI attached, which is indicated by another attorney of the Salomon Schools, lawyer Hubert Kubik, in a letter of 7th December 2015 and reattaches more than 1,000 pages valid for the case of the documents. Evidence letter from the law office of the 7th December 2015 attached, which, as it underlines in this letter, was certified and forwarded to the controlling authority on June 6th, 2014 by the attorney at law advisor Piotr Kołodziej, and are not in the files of the proceedings. In addition, he points out that the documents, due to their nature, are important for the resolution of this case. In a letter dated 16 September 2016, the Deputy Mayor of Praga District North to the plenipotentiary of Salomon Schools Legal counsel Michał Czarnik, evidence letter UD-VII-WOW.1431.3.2016.BBA attached, refuses to provide part of the indicated documents on public information registered in the Central Register of Requests for Public Information under the number CRWIP/5372/2016, with comments, as emphasized by the fact that documentation regarding the above proceedings in its entirely has been transferred to the local government appeal court in Warsaw. According to information obtained from SKO by Dominik Jelonek, the plenipotentiary of the party, by June 2017, the office of the capital city of Warsaw did not forward the documentation referred to by the deputy mayor to the SKO, said. The MKO also avoids explaining the actions taken towards the Salomon schools, as indicated by, for example, the letter from December 1, 2016, addressed to the legal advisor of Michał Czarnik by Mrs. Magdalena Cichostemska, evidence key PU.571.111.2016.JL, in which she becomes a spokesman for the education office of the city of Warsaw and encourages the deletion of the high school Salomon in Warsaw from the register of schools and non-public institutions run by the capital city of Warsaw. That's sad. In this jurisprudence, the view emerges that in assessing whether there has been a violation of the personal good, the subjective feeling of the person demanding legal protection is decisive. But what is the relation in the society that is the basis for this demand? Judgment of the Supreme Court, Chamber Civil of May 19, 2004. When submitting the above decision to the facts of the case, it is clear that the violation of the personal good of the Zakrzewski family undoubtedly occurred. Mrs. Hanna Gronkiewicz-Waltz introduced and used the protocol and post-control statement before state institutions, police, CBA, prosecutor's office, UKS, US, etc., natural persons and legal persons in order to discriminate against the Zakrzewski family. The report and the post-control speech contained untruth. Most importantly, the chairperson of Salomon School was deprived of the possibility of reaction and defense, since the protocol and post-control statement is not an administrative decision with which the party can take up the polemic with regard to the facts and with regard to compliance with the law. Notification of the possibility of committing a crime was based not on a decision and on the protocol and post-control statement containing subjective conclusions conducting the inspection. The President of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, should refrain from taking steps to punish civil, tax and civil liability of persons running Salomon schools until the decision on reimbursement of the awarded subsidies becomes valid. As the appeal court in Białystok ruled in its ruling of 18 May 2016, reference number Act 1 ACA 54/16, that filing a notice of suspected offense may not only be an unlawful act, but also a tort, as defined by civil law. Activity of the President of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, shows unlawfulness, but also violates the good name of people who created and sponsored the Salomon schools, Mr. Paweł Michał Zakrzewski and Marzena Zakrzewska. It should also be emphasized that notice of the initiation of administrative proceedings regarding the return of subsidies was issued by President of the capital city of Warsaw. The use of the protocol as well as the post-auditor statement prior to the initiation of proceedings made it impossible to effectively defend the persons concerned. President of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, was able to freely pursue her own goals related to destructions of the social authority of the Zakrzewski's family in the scientific, educational, political, and business dimension. Activities of the Mazovian Education Office and the Regional Examination Commission in Warsaw. The Mazovian education supervisor harassed the Salomon schools with checks that were very often in excess of the procedures for carrying out the checks, and the school management was repeatedly forced to use the way of complaint. And the initiative of the president of the capital city of Warsaw, Mrs. Hanna Grunkiewicz-Waltz, Mazovian Board of Education, hereinafter MKO, as well as District Examination Commission in Warsaw, hereinafter OKE, have also started inspections of educational institutions in Salomon. In 2014, at the time of the inspection conducted by BKU and MKO, OKE also tried to carry out parallel checks at the Salomon schools. By letter BE-WPSN.443L.118.2015.AOG of April 16, 2015, the authorities of the capital city of Warsaw kindly informed the Mazovian superintendent of schools about irregularities in the Salomon schools. Of course, based on post-control comment asking for urgent controls. That the officials of the capital city of Warsaw filed this letter in person at the IOC, and the note is written in an official by the MKO employee. The correspondence quoted explicitly testifies that the capital city of Warsaw is exerting pressure on the Mazovian Superintendent of Education in order to harass Paweł and Marzena Zakrzewski Salomon schools. MKO controls were conducted in a very severe way for all Salomon schools. In particular, the reservations are raised by the fact that the audits were conducted during the period of examinations, during the period in which the entire teaching staff should be involved in the course of exams and not during the MKO control. The governing body of Salomon schools asked for setting other control dates. These letters were also sent directly to the Minister of National Education. Requests aimed at the good name of students did not bring the expected results. Controls were carried out at the planned examination date. Then, the headmaster of Salomon schools informed the MOC about this, citing Article 12, Paragraph 3 of the Regulation of the Minister of Education of 7 October 2009, and indicating that conducting inspections at school or institution cannot interfere with the school's work, and the control should not last longer than 2 business days. These similar activities of the MOC were repeated over the course of 4 years several dozen times. Additionally, at the time when MKO was planned to control, the OKE and BKU inspections were already underway at Salomon schools. Such concentration of controlling authorities prevented the proper functioning of educational institutions. Thanks to the intensified and fruitful efforts of Paweł and Marzena Zakrzewski, as well as the teaching staff, normal conditions for education were provided to students, and the fact that the victims, apart from Zakrzewski's, the management and didactic staff could become students themselves. The controls were aimed at humiliating the Zakrzewski family and presenting the Salomon schools as institutions that are unable to pursue their educational goals. The controls were to lead to highlighting the weaknesses of home education, a confirmation of this position on numerous staff memos who indicate that the inspectors did not want to get acquainted with full documentation of Salomon schools, which was important from the perspective of conclusions coming from the control. The audit was carried out for the mere fact of the audit and was supposed to confirm the thesis made in advance and did not explain any significant issues. The controls were so cumbersome that the students themselves reported complaints about the actions of the controlling people. In response to the complaints in question, a letter was written to the Minister of Education. Complaints submitted in writing did not bring any improvement. It should be noted that Salomon schools always followed the post-control recommendations, even if the way the controls were carried out and the accusations unfounded were simply clinging to irrelevant matters or debatable details. In spite of the explanations from the Salomon schools, the MOC carried out audits of the recommendations issued, and it included an incomprehensible clause urgent. In this context, the cite letter from the capital city of Warsaw BE-WPSN.443.118.2015.AOG from 16th April 2015 and letter MKO/KOG.553.51.2015.WP dated 11 May 2015 may testify to the willingness to meet some of the specified timely commitments of the MOC in relation to the authorities of the capital city of Warsaw. Determination in the fight against Salomon schools, Paweł and Marzena Zakrzewski, was demonstrated by the Mazovian school superintendent who did not accept the appeal, the Salomon schools directorate, because, as he put it, we have exceeded the deadline of 7 working days. Let us add that for one day, the main reason for this decision was supposed to be the alleged lack of students in school in 2015-2016. As it follows from the documents of the ad hoc board on January 21st, 2016, the head of the Department of Education and Education Board of Praga Północ District Office had information that there are currently around 100 pupils in the Salomon schools. It was surprising for the plaintiff that the information was sent by the president to the District Examination Commission in Warsaw. The subject of OKE's activity in the preparation and organization of an external assessment system, test after primary school, middle school exam, vocational exam and extramural examinations in the area covered by its activity. The OKE representatives' harassment during gymnasium examinations is confirmed by the fact that the Salomon schools were groundlessly accused of improper preparation for the gymnasium examination. Evidence in the form of business memos testify about the coordination and cooperation of OKE, MKO, and the authorities of the city of Warsaw. All the activities undertaken by all the inspection bodies in Salomon schools were interrelated and coordinated by the same entity. This is indicated by the exchange of correspondence between the District Examination Commission in Warsaw, the Mazovian School Superintendent, and the Education Office of the capital city of Warsaw. Salomon schools in Drohicin. The activities of the police, CBA, prosecutor's office, UKS, etc. were directed not only at control subsidies, but above all for the person of Mr. Paweł Michał Zakrzewski as well as Mrs. Marzena Zakrzewska. An example of such an operation can be an operation combination at the Salomon schools in Drohicin. Salomon schools were run by Foundation International Center for Applied Theology, whose founders Paweł and Marzena Zakrzewski. This institution in 2015 did not receive subsidies and was intensive and unjustifiably controlled like all Salomon establishments. According to the plaintiff, it was clear that the controls were aimed at eliminating educational institutions that supported education at home, as well as people who created, labeled, and financed them to a large extent. After the actions of Mayor of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, was the perception of Salomon schools as criminal organizations, as evidenced by this requisitioning by police with weapons in hand, schools' documents and equipment preventing the work of the Salomon schools in Drohichin. The documents were kept in Białystok at the local Board of Education in consultation with prosecutor's office. Despite the discontinuance of the proceedings, oversight crimes, the documentation was not returned and the copies received from the originals were provided subtitles, among others, during the course of the proceedings. The above actions clearly testify about personal attacks on the person of Paweł and Marzena Zakrzewski as sponsors and founders of establishments in Warsaw and Drohichin. All the activities undertaken by all the inspection bodies in Salomon schools were interrelated and coordinated by the same entity. This is indicated by the exchange of correspondence between the District Examination Commission in Warsaw, the Mazowian School Superintendent, and the Education Office of the capital city of Warsaw. Salomon schools in Drohichin. The activities of the police, CBA, prosecutor's office, UKS, etc. were directed not only at control subsidies, but above all for the person of Mr. Paweł Michał Zakrzewski as well as Mrs. Marzena Zakrzewska. An example of such an operation can be an operation combination at the Salomon schools in Drohichin. Salomon schools were run by Foundation International Center for Applied Theology, whose founders Paweł and Marzena Zakrzewski. This institution in 2015 did not receive subsidies and was intensive and unjustifiably controlled like all Salomon establishments. According to the plaintiff, it was clear that the controls were aimed at eliminating educational institutions that supported education at home, as well as people who created, labeled, and financed them to a large extent. After the actions of Mayor of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, was the perception of Salomon schools as criminal organizations, as evidenced by this requisitioning by police with weapons in hand, schools' documents and equipment preventing the work of the Salomon schools in Drohichin. The documents were kept in Białystok at the local Board of Education in consultation with prosecutor's office. Despite the discontinuance of the proceedings, oversight crimes, the documentation was not returned and the copies received from the originals were provided subtitles, among others, during the course of the proceedings. The above actions clearly testify about personal attacks on the person of Paweł and Marzena Zakrzewski as sponsors and founders of establishments in Warsaw and Drohichin. Disinformation media campaigns. It should be noted that Paweł Michał and Marzena Zakrzewski, as a result of activities of the mayor of capital city of Warsaw, Hanna Gronkiewicz-Waltz, have been repeatedly exposed to unfair assessment by publishing articles in the traditional press and on internet portals, where the Zakrzewskis were described by the following comments. What happened to everyone from Salomon and Zakrzewski? They retired? They escaped after these scams. They steal, they're up to something, but it's the system's fault. There is no punishment for it, and one look at the others and go. It is worth noting that the above-mentioned articles refer to sources Metropolitan City Hall and introduce the reader to the belief that the administrative process has been terminated and the Salomon schools had to return a certain amount of money. The opinion of the Supreme Court of August 17, 2016, IVKK 53/16, objection in the sense of the provision of the Article 212 of the Penal Code. It must be a statement about facts, for it is a statement that can be subjected to the proof of truth provided for in Article 213 Penal Code if it is verifiable. Then it will be a slander, and if it is unreasonable, it may be an insult. In judgment of the Supreme Court of 13 October 2015, counterfeiting permitted criticism was specified by the legislator in the Article 213, paragraph 2 of the Penal Code. The allegation was false, which was also accepted by the Court of Appeal, rising, it is not the exercise of the right to criticize a person holding a public office, as well as the Supreme Court judgment from 17 May 2017, 3 KK 477/16, the subject of protection of the provision of Article 212, paragraph 1 Penal Code. It is the honor and dignity of a person who is being talked about or is likely to humiliate the public or expose them to the loss of confidence needed for particular position, profession, or activity. On the other hand, the need to protect such values as the freedom of expression and the exercise of the right to court is undoubtedly raised by rising arguments in the pleadings, including the conduct of another person whose property. The above rights and freedoms, however, are not unlimited, which means that it is unacceptable to cross certain limits, especially in the protection of the honor and dignity of others and respect for their rights. The non-statutory counterpart of the right and authorized criticism refers only to situations in which such criticism is necessary to defend a legitimate interest. It is necessary to infringe the reputation of another person or collective entity. Going beyond the framework of necessity results in liability for defamation. An article constituting inter alia a statement of the deputy president of the capital city of Warsaw on behalf of the city, in which he gives false information about alleged abuses in the Salomon schools, fictitious schools. It should be noted that Paweł and Marzena Zakrzewscy had not been convinced or prosecuted by any state authorities. Tax proceedings, like all others initiated at the initiative of the president of the capital city of Warsaw, Hanna Gronkiewicz-Waltz, was characterized by disproportionate insistence and oppressiveness, as well as lack of respect for individual rights in relation with state authorities. In connection with the inspections carried out for the Zakrzewski's family in 2014-2017, numerous complaints were lodged against abuse of power and abuse of powers by officials, including a notification to the prosecutor's office about the possibility of committing a crime. The social institutions, among others, our association, joined the complaints. It should be noted that the Ministry of Justice has referred the case to abuse of power and acting to the detriment of Paweł and Marzena Zakrzewski by state officials to the National Public Prosecutor's Office. Marzena Zakrzewska, as a citizen, always respected the legal order in force in the Republic of Poland and consulted with the authorities of the Polish state, including her tax obligations. From the inspections carried out in Salomon schools, Paweł and Marzena Zakrzewski, a protocol and sub-inspection statement were prepared. These documents were unlawfully publicly disseminated prior to the initiation of any administrative proceedings. In this regard, the Supreme Court's thesis of 3rd December 2010 in the case of 1 CSK 95/10 states, there is no reason to share the view that freedom of expression as a pillar of the democratic social life justifies the violation of personal rights by providing information inconsistent with reality or unfoundly unfair evaluations. even if there was a dispute between the spokesperson and the one he exchanged. The president of Warsaw, Mrs. Hanna Gronkiewicz-Waltz, made a notification to the Central Anti-Corruption Bureau, Prosecutor's Office, UKS, MKO, OKE, on the basis of the challenged protocol and post-inspection statement. The scale of activities undertaken by the president is inadequate and does not match the activities of Salomon schools. The criminal proceedings were discontinued and the incorrectly administrative issues were successfully contested and unfounded to the SKO, for Zakrzewskis lost their property, social authority, and the scientific dimension, as well as in the eyes of parents of Salomon schools pupils and the board social opinion, and the Salomon branches themselves were deprived of their functioning and illegally dismantled. Analyzing all the activities undertaken by President Hanna Gronkiewicz-Waltz, should be stated that we are dealing with a violation of the personal good of Zakrzewski's family. That is honor. In doctrine, honor is understood as the person's condition to defend his values, in a way justifying the respect of other people. For Zakrzewski family, the greatest value was presented to the family, and moreover the possibility of entrusting education to the family. Zakrzewski are currently raising 10 of their juveniles. The defendant tried to destroy these values by initiating operational activities of various state organs. In his thesis of January 21, 2005, reference number CK 316/04, the Supreme Court stated, assigning the effects of a natural person to a legal entity is justified when this person occurs as carrying the will or knowledge of a given legal entity with all consequences resulting from it, and does not publish its own content. Then he cannot free himself from responsibility for the consequences of his actions. It is important to distinguish the internal aspect of honor, called in this context personal dignity, consisting in convicting a man of his own worth and waiting for respect from others, and its external aspect, called a good name, based on respect and positive opinion of the environment. Both in internal aspect and the external, President of Capital City of Warsaw by its actions violated the honor of Mr. Paweł Zakrzewski and Marzena Zakrzewska. These actions undermine the confidence and authority of the Zakrzewski's family. Regardless of the application of the order of Article 23 of the Civil Code, legal protection can be seen directly in the provisions of the Constitution of the Republic of Poland. As the constitutional doctrine indicates, the violation of honor consists in particular in assigning to the person attributes or properties that may diminish it in the public opinion or expose them to the loss of confidence needed for a given position, profession, or type of activity. The reaction of the average recipient, the reaction evoked by society in the event constituting the basis for the protection demand, determines whether there has been a violation of honor. The source of a violation of the honor and good name of an individual may be the activity of public authorities, which cannot be granted freedom of speech within the meaning of Article 54 of the Constitution of the Republic of Poland. President of the Capital City of Warsaw, Hanna Gronkiewicz-Waltz, as well as the officials acting on her behalf, undertook a number of unlawful actions based on subjective conclusions that were aimed at achieving recognition of Paweł and Marzena Zakrzewscy as persons guilty of introducing a threat to the order and security of the state. These actions had a direct impact on violation of the dignity and good reputation of Mr. Paweł Michał Zakrzewski and Marzena Zakrzewska, In the justification of the Constitutional Tribunal's decision of October 13, 2006, reference P10/06, reads, "Intervention in the sphere of human dignity is such a significant violation of the foundations of the state and social order that it ceases to be only an individual matter of those concerned. What is more, in the provided in Article 10, Convention on the Protection of Human Rights and Fundamental Freedoms, Journal of Laws of 1993, number 61, item 284, as amended. For all these important reasons, I bring in as at the beginning. Attachments. 1. The evidence indicated in the statement of reasons for this claim confirmed for compliance with a copy of 1567 pages. 2. A copy of the statement of claim with attachments. 3. Court fee 600 zlotys.